Hello, welcome to this week's lunch workshop for the AI initiative. This is our last one of the spring. I hope that those of you who tuned in and those of you who regularly attended think this is worth doing next year, because that's our plan come the fall with a whole new lineup of speakers. We couldn't end this series better than have our own Mark Lemley come to talk to us about AI and copyright. And Mark is known to everybody in this law school and in the field. He is the director of our program of Law, Science, and Technology. He is the William Newcomb Professor of Law, and is the biggest utility player, I think, in legal academia, not only litigating cases, but seemingly publishing a different law review article every day, as well as being active in the public conversation on all these issues. As is our tradition, he'll talk for around half an hour, and then we'll take questions. We can go as late as 2 if there are a lot of questions, which I suspect there will be. I'll do a moderated discussion with Mark right after he talks. Those of you on Zoom should put the questions in the Q&A, and they will magically appear on my phone as I'm up there with them. So without further ado, Mark Lemley.
Thanks, Nate, and thanks everybody for being here. I'm going to move this down slightly because I am loud enough, even without the microphone, I suspect. What I'm going to talk about is copyright and generative AI. There are a bunch of legal issues, of course, that you've been hearing about, but the one that has made it into the courts quite a lot is copyright. And it comes from the fact that, right, as we call it generative AI because it makes things up. Right, I asked Midjourney to give me a picture of penguins having a cocktail party at the beach, and here's what it gave me. I confess that I did not expect the penguins to be in the cocktails. It came up with that on its own. But if you ask ChatGPT to give you images of penguins having a cocktail party at the beach, you might get something very different, right? And these are a bunch of different kind of very Monet-style penguins. And even within the pictures, you've got a bunch of different variations, right? So AI generates an enormous array of things, quite often things that we didn't necessarily have in mind when we asked for them. How does it do that? Well, it does that by training on an enormous amount of data. And it turns out, in the world we live in, virtually everything that you might find on the internet is copyrighted. You could possibly train an AI on works written before 1929. It would probably speak rather differently and know a bunch of different things than the AIs we have right now. But if you train on anything since 1929 or 1930, you're going to be running into copyright law. And that means you're going to be running into copyright lawsuits. There are over 100 copyright lawsuits in the United States, as well as many abroad, and that are pending right now. And the copyright lawsuits present 3 basic sets of issues. Is training AI copyright infringement? That's what most of the lawsuits have been focused on so far, and it's what the few decisions that we have so far have focused on. Second issue is the output of AI copyright infringement, and those cases are now coming increasingly as well, and we'll talk about that. And the third and final question is, who owns work created by AI? So I'm going to talk briefly about all 3 of those topics. So, training, as I said, involves copying giant sets of data. Billions of images, right? Trillions of data inputs. For the most part, big exception, which we'll talk about in a minute, those copies don't appear in the output. Right? For the most part, I train on the data. The AI generates things like penguins having cocktail parties at the beach that are not, in fact, just taken from their training data. We have two court decisions, both from the Northern District of California, on the question of whether that training, which makes an intermediate copy of a whole bunch of things off of the internet and books, is lawful under copyright's fair use doctrine. And those two decisions both say, yes, training is fair use, although one of them does it really grudgingly. The basic rationale behind that is fair use is a multi-factor test. We consider a bunch of individual facts. But the courts, I think, agree that the use that is being made of the training data content is a transformative use, right? We are not taking this work in order to just replicate the work. We are taking this work in order to make a fundamentally new thing, right? A model that in turn generates lots of its own content. And that is a strong reason to treat use as a fair use. It is creating new things, and creating new things is one of the things we want to do in copyright law. Second, the court points out the copy is only temporary in training the model. We make an intermediate copy that sits inside the server of the OpenAI. We don't share that with the world. And the model itself, the courts say, more on this in a minute, does not make its own copy of the works. The model itself is just a sort of collection of weights of word relationships. And third and finally, the courts say, well, there's no market harm. And there's, in the sense that you're not actually selling the copyrighted work into your output, and there's no established market for licensing content for training. Now that also turns out to be changing, right? The very companies whose lifeblood depends on winning fair use cases, and who are winning fair use cases because they have been able to persuade the courts that there is no licensing market for training data, are also in the business of going out and signing licensing deals for training data. So it's not clear that the next company down the line that encounters one of these lawsuits is going to have the same result. That might be one part of the business not talking to each other. It might be a deliberate decision for anti-competitive or other reasons, right, to sort of pull up the ladder behind you. So I do say grudgingly, right, I will note one court says, you know what? I'm going to find that this is fair use, but I'm going to find that this is fair use only because you didn't make the argument I wish you had made. And the argument I wish you had made is AI makes content, new content, and that new content competes with existing authors, and that should be illegal. Now, the plaintiffs didn't make that argument because it is not the law. It is flatly foreclosed by existing Ninth Circuit precedent, but the judge really wanted them to make that argument, and so I think we'll see some people trying to push at that law in the future. The other judge who said this is absolutely, definitely fair use, you can clearly train, no question, easy case, also said, but by the way, if you got the content illegally, you might be separately liable for that. And in that case, Bartz versus Anthropic, the parties then settled with a payment not based on the training, which the court said was legal, but based on the access to the book's data in the first place. All right. Second question, and this one has not actually mostly been litigated, but I think it's coming, and it's something I want to talk a little bit about because Cooper and I have done some interesting research on it. Some plaintiffs early on said the model itself is a derivative work. Right? So yes, the training data sits in a separate temporary file. It's not ported over into the model, but the model itself is a derivative work. The courts rejected that argument because it was, as it was made, the idea was, well, you trained the model on the works, therefore it must just kind of contain them all somewhere in it. And that's not true. To be a derivative work, you actually have to have a copy of the work or something substantially similar to the work in your model itself. And models don't, and generally can't, incorporate all the content they train on. Right, so take an example from the image world. There are 136 billion images online. If we said there's something like 500 kilobytes for a 1 megapixel resolution, we're talking about 68 petabytes of image data online. Stability AI's model is 6.9 gigabytes. It trains on all of these images. It's 1/10,000,000th that size, right? Now, maybe we have just created the best compression algorithm ever generated. And I do think there is a sense in which you can think of these open models as compression algorithms, but they are clearly not lossless compression algorithms, right? We have not stored all of the information from all of these images in a particular model. Text, of course, doesn't take quite as much to store, and models are able to reproduce some pieces of some content, and the work that has been done so far kind of suggests something like 2% of the text that they train on may actually be resident in the model. That's, again, not most of the model, and it's not most of the things on which you train, but it does suggest that there are some works for which we are storing, if not a complete copy, a pretty good copy in the model itself. And I think one of the things we show is that there are some notable exceptions. As you'll see in a minute, Llama 3.1, for instance, from Meta, copies all of Harry Potter in the model, and you can reproduce it essentially verbatim without too much effort from the base model itself. So there clearly is a copy of Harry Potter resident in the model. And as models get bigger, they have more capacity, right? This amount of memorization may increase. All right, so what do we know about this, right? So one thing we know is that you can, in some cases, extract training data from these models, right? I can pull out things that were in the training data. One of my favorite examples of this is the poem attack. Nazar et al. In 2023 ask a model to generate, just say poem, repeatedly over and over again. And it does that for a long period of time, and then it randomly starts spitting out other things that are in its training data, some of which include personal information, phone numbers, and websites of random people that it has been trained on. Now, this obviously isn't what the model people intend, right? It's not what the sort of prompters generally intend. You can try to make this problem go away, right, by using post-training and alignment. So one of the things you can do is you can build in safeguards that say, don't reprint Harry Potter. Right, even if it's trained in the model, don't give it to me as your output. Doing that kind of reduces the amount quite a lot that you can get out of a model of copyrighted works. But you can also do attacks like poem that will actually sort of trigger or generate content from the model, and that significantly increases the amount of copyrighted material you could get out of these models. But it increases it to, we're talking here in the 2023 paper, 2.5–3% of the works, right? Definitely not most of it. What Cooper and I find, we take a bunch of the books, we take 200 books that are trained in the various models, we run them through various models, and kind of run a test at where we say, all right, if we give it 50 tokens from a book, how likely is it to reproduce the next 50 tokens in that book faithfully, right? And then we march through each 50 token sequence in the whole book for each of the 200 books. And what you get is a very different set of answers. Different by model, right? And different by book, right? So here's Harry Potter. You can see blue is exact duplication from this 50 token sequence. Most of it's blue. Most of Harry Potter from a 50 token sequence will just get generated. Not all of it, but most of it. Much less from Llama 1, which is a much smaller model. Virtually nothing from Pythia. Right? Every book turns out to have some things. These are the copyright notices. They're copyright pages or the author pages. Copyright pages show up in all the books, and models will faithfully reproduce them even if they don't actually train on the book, because they're like, oh yeah, this is a Random House copyright notice, and so it generates the thing. So contrast Harry Potter with Lean In. Lean In gets virtually no copying, even in the models that otherwise significantly generate. So this memorization varies substantially by model, right? In these papers, we tested open weight models. There is a separate paper by Ahmed et al. That actually does kind of attacks against the proprietary models and finds something similar. Pythia, virtually nothing gets duplicated. Llama 3.1, much more duplication across a range of things, right? Note that each model treats a particular book differently, right? And that each book, right, is different in each model. So there's not a simple answer to the question of is there memorization here, right? The answer is it depends. Depends on the model, depends on the book. Most of the books look like Madame Butterfly. Very little copying. Where there is copying, right, often, as we'll see, turns out to be a potentially because of duplication in the data set. If there's one quote that everybody uses from a particular book, well, that quote often turns out to show up in multiple websites, and so that gets kind of reinforced in the model. So most books, very little copying. Quite a few books, right? A decent amount of copying, right? Not most of the book, not a large chunk of the book, but individual slices here and there do look like they're memorized in the model. And there are a few books, right, that look like Harry Potter. A lot of blue, a lot of copying. All right. So, is this just monkeys at typewriters, right? One of the things, what we did to get this result is we ran thousands of different queries, right? We ran the same query thousands of times. What we're showing you is, right, does this show up more than one time in 1,000 when we run the queries, right, in the base model? So this isn't, you do not try this at home, right? If you try this at home, you're not working on the base model, you're working that's been safeguarded, you won't get Harry Potter. And B, right, if you try this at home, you might have to try it a bunch of times before you get Harry Potter. But it is not just monkeys at typewriters. We tried this on books that are not memorized in the database, books that are published after the date of the database, for instance, and it turns out there's nothing. Right, with the possible exception of the copyright notice. And indeed, when you look at the data, the chance of generating all of Harry Potter by accident through random chance from a model is about 1 in 10 quadrillion. That's the equivalent chance of winning the Powerball 34 million times in a row. Right? It's not going to happen by accident. If it happens, it's because there's memorization in the model. All right, but it turns out there's more than just memorization in the model in a kind of abstract sense. If you use a technique that we call constrained beam search, we can take a single prompt, right, from a heavily memorized book. This is Mr. and Mrs. D. These are the first characters of of Harry Potter, Mr. and Mrs. Dursley of 4 Privet Drive. If we generate that, it will tell us faithfully that it is Mr. and Mrs. Dursley of number 4 Privet Drive. And doing this, and then taking the text it generates and feeding it back into the model, we deterministically reconstruct the entire book, essentially verbatim. The highlights here are the things that are different, and the differences are all, it's a 3-dot ellipsis versus a 4-dot ellipsis, or we spelled mum in the British way rather than the American way, because it turns out, for whatever reason, they had a copy of the British book and not the American book in the training data set. Again, this is not true across the board. So here is Sandman Slim by Kadri, who is one of the named plaintiffs in the Meta case. The blue is the text that comes from the Kadri book. We put it in, and then everything below that we put in blue is a copy. There's nothing in blue after the prompt, right? It turns out, actually, interestingly, to be talking about Sandman Slim and James Stark, a character in Sandman Slim. It clearly knows that this is a book, but it has not memorized. It does not generate as an output in the book. All right. So what does that tell us from a legal perspective? We can get some extraction. We can show that the models have memorized some of these works, right? But they encode that work probabilistically. Right? And I'll show you how that works in just a minute. What we get, the output, is the end result of a probability tree of a bunch of different word results. That, if the probabilities are high enough, you're going to get Harry Potter as it was originally written. But if they're not high enough, you're going to start to diverge and ultimately diverge more and more. Whether you get Harry Potter, whether you get Madame Butterfly, a particular piece of it, may depend on which of 1,000 or 10,000 different times you run the same prompt through the same model. That's going to be a problem for copyright law. Because copyright laws just have not dealt with this idea of probabilistic copies. I think we will see lawsuits coming in which we say, the plaintiff says, the model itself is a copy, And so making a copy of the model makes a copy of my book, and that is an act of infringement. There are some reasons why that might get resolved differently than the fair use cases that have already been resolved. But it's not clear to us that this is in fact something we should treat as a copy. Right? Even if it is a copy, the UK court says not a copy in the model itself. But even if there are copies in the model of something like Harry Potter, that might still be a fair use. Right? It's still mostly transformative. We're not using these models mostly to generate copies of Harry Potter. If you want to pirate Harry Potter, there are much easier ways to do it. But I do think one of the potential changes and the potential worries is open source or open weight models may be particularly vulnerable, right, to this copyright argument because the model itself is distributed. If you conclude that the model is a copy, well, OpenAI makes a few copies probably at home behind its paywall, right, to sort of operate different servers. But Llama is an open source model, and so every time you distribute a copy of Llama, if you are distributing a copy of Harry Potter, now you're on the hook for copyright infringement. So one potential from this legal doctrine would be open source, open weight models are facing greater copyright liability than proprietary models. That seems kind of worrisome. All right. So I said this is a probability tree, right? If you look at the way these things actually work, so we put in Mr. and Mrs. Durs. Here's the probability that we get a particular next token out of that. It is quite high to say Durs-Lee. Probably going to give you a comma, but not necessarily. It's only about 80%. Very highly likely you're going to get the word of after the comma. If you just take the top ranked number, that's how you can pretty easily get Harry Potter because it is heavily memorized. But if you just ask a question and you don't take the top ranked number, right, you could actually and probably will diverge down the tree at some point later. Here's another example from a different book. The famous quote, if we generate the famous quote, will we generate the next language from F. Scott Fitzgerald? The answer is sometimes yes, sometimes no. Again, depends on the model, right? Llama 3, very different than Llama 1. Even among Llama 1, the larger model is different than the smaller models. So what does this tell us? Memorization isn't just a single number, right? Different models memorize at different rates. Model itself might be a copy. That legal issue is coming, but it's not something we've resolved yet. Next up is output. The output of generative AI, I started this talk by saying the output of generative AI is usually not substantially similar to the input, right? So Anderson versus Stability AI, the first case filed in this, Sarah Anderson is a cartoonist. I went to Stability AI and I said, give me a Sarah Anderson cartoon. This is an actual Sarah Anderson cartoon. This is the kind of thing it is. This is what Stability AI gave me. This is clearly not a copy of this. I think they were aiming to have a picture of Sarah Anderson with early AI kind of can't do faces yet thing in a comic strip, but it's clearly not a copy, right? Even if you prompt it to try to get a copy. And that's the normal range of things, right? If I ask for penguins having a cocktail party, I don't get existing images of penguins attached. I get newly generated things. But there are exceptions, right? One exception is this memorization, and particularly a duplication problem, right? So Carlini has shown for some pictures, for some works, you can get an image that pretty clearly comes from a particular trained work. That's especially likely, it is especially true if that text or that image exists multiple times in the training data set, right? It's not clear that they're just copying an image. They may actually be generating an image from the 100 closest sources. It's just the 100 closest sources all turn out to be the same picture, right? Or the same text of Harry Potter, right? So that's a problem in circumstances where it occurs. Second problem, is that we got a bunch of plaintiffs' lawyers out there who are deliberately working hard to try to generate output infringement. And so if I want to prove that your model is infringing, what do? I want to get the best possible thing that looks like a copy. So in the Getty Images versus a Stability AI case, the plaintiffs worked really hard to get a copy of this image out of the model. They didn't, I think, end up doing a very good job, right? And even if you prompt, give me two soccer players, right, fighting over the ball with their arms and legs akimbo, taken from a ground-up shot with a Getty Images watermark, and one of them's wearing red and one of them's wearing white, you still don't end up, you end up with some similarities, or you don't end up with the same image, right? You don't end up with something that I think is substantially similar. You do, interestingly, end up with a blurry Getty Images version watermark in there, and that presents a trademark and not a copyright issue. But if you try hard enough, right, you can quite often get more exact text. So this is from the New York Times lawsuit against OpenAI. It's their big exhibit. It says, here's a New York Times story. Here's an almost identical copy generated by OpenAI as output. And the complaint says, we got this with minimal prompting. If you go beyond the complaint and read the exhibits, minimal prompting means we said, give us a New York Times story from this date with this title that begins with these first 8 paragraphs. And once you did that, you actually did get text, right? If the question is, did you memorize that story? Yeah, this is pretty good evidence you did. If the question is anyone in the real world likely to encounter this story by using OpenAI in their normal course of business, right, the answer is probably no. Although an interesting use case, right, is can I use this to get around newspaper paywalls, right? If I copy the first few paragraphs that the newspaper allows me to see, maybe I can get something more than that. So this is a problem, I think, because one of the ways we're going to present these things to courts is with lawyers kind of doing their best to gin up acts of infringement that are not, in fact, the way the models normally work. A third potential copyright exception where we might get output is the in the style of request. Give me a painting in the style of Thomas Rutkowski. That, I think, the models actually are better at doing. We actually even have in OpenAI the Ghibli filter that will allow you to basically turn everything into a Studio Ghibli image. The problem, I think, for copyright law is that style is not copyrightable. At least we say consistently style is not copyrightable. Mostly we mean it. Occasionally we kind of change our minds and we say, well, style isn't copyrightable, but boy, Blurred Lines looks an awful lot like that Marvin Gaye song in feel, even though we can't actually find anything that was copied, so maybe we'll make an exception. I think one of the things where we might see copyright law change is around this style question, right? I think if you're deliberately generating a filter whose whole point is copy the style of a particular artist, right, there's a plausible economic argument, right, that we probably ought to be paying the artist for that, but right now at least we're not. Then we come to the biggest problem that the AI companies face, right, which are copyrighted characters, right? It turns out that AI is really good at generating copies of copyrighted characters. If you ask AI to give you Darth Vader, it will give you a pretty good Darth Vader. If you ask it to give you Baby Yoda in preparation for the movie opening today, it will give you a very good Baby Yoda. And even if you kind of design around that, or even if you build a guardrail that says, do not respond to requests for Mario, if you ask it to give you a cartoon version of an Italian plumber, you're going to get something that looks an awful lot like Mario. Because the model knows, right, that this is a concept in the world, just like kitten or coffee cup is a concept in the world. And so I will generate an aggregate image of a Darth Vader that looks an awful lot like the Darth Vader. The problem is the Darth Vader is copyrighted, kittens are not. Right? All right. We've got other problems as well. Retrieval augmented generation, I think, does expressly try to take text from a particular source, and so that is much more likely to generate output. It's much more likely to need licensing permission. One of the things that I'm just starting to explore now is how much of the code that the Claude codes of the world are out there generating, right, turns out to be basically taken chunk by chunk, function by function from different code that already exists, and that either is copyrighted and proprietary, in which case you've got a copyright problem, or is open source or free released, in which case you've got a very different problem if you just built that into your software. I don't have data on that, but I suspect there's going to be an interesting issue. All right, final thing I'll talk about, who owns the result of your AI-generated work? And here we have an interesting problem. Copyright law says only humans can be authors. Big parentheses, or corporations, because corporations, as we all know, have more rights than humans, and so we always make an exception for them. But as a general rule, the court says only humans can be authors, and it's this guy's fault. This is Naruto. Naruto is a crested macaque who picked up a camera and took a selfie that went viral. And once it became clear that it was going viral and everybody wanted this selfie, the guy who owned the camera said, I am the copyright owner because it's my camera that took this picture. People for the ethical treatment of animals said, no, the monkey owns the copyright. The monkey's the one who took the picture, right? Which is strictly speaking true. This went to the Ninth Circuit, and the Ninth Circuit said, no, monkeys can't own copyrights. Only humans can be authors. On the strength of that rule, the Copyright Office and now the DC Circuit have said that means work created by AI is not copyrightable at all. Thaler versus Perlmutter, even in circumstances like this one, where an entirely AI-generated work would clearly qualify for copyright protection, right? It's sufficiently original if it had been generated by a human. Now, the Copyright Office does say you can get protection for the human elements you contribute, just not for the things the AI contributes. So then we started to think, well, what about prompt engineering? Hey, I'm the one who kind of, encouraged the painting to look that way. No, says the Copyright Office. In Zarya of the Dawn, the human writes the text, the AI generates the images. The Copyright Office says, fine, you can have a copyright in the text, but the AI generated the images, even though you asked it to generate the images to match the text and to tell the story. Too bad. Doesn't even matter if you try 500 or 600 times to refine your prompt to get just the painting you're looking for. This is an AI-generated painting that wins first place at the Colorado State Fair before they find out it's AI-generated. The fact that the artist spent a bunch of time and effort trying to prompt it to get this does not make it copyrightable, according to the courts and the Copyright Office. AI made it, AI owns it. This, I think, is going to turn copyright law on its head. In a couple of important respects. Copyright law protects expression, but not ideas or functional elements. And that has worked pretty well for us historically because historically making the expression has been the hard part. All right, I come up with an idea. Let me do a painting of people having a party in front of a giant planet. But then I actually got to do the hard work of doing the painting, right? Making it look, realizing the vision. AI makes that expression part easy, but also uncopyrightable. The idea is not owned. If you own anything, it's going to be in this kind of weird middle ground, right, of maybe writing a copyrightable text prompt, right, or doing kind of Photoshop-like work where you actually make specific modifications to the AI-generated painting, but the only thing you will own are those specific little modifications, right, not the overall work. The other problem it creates, I think, is that it makes it very hard for us to know whether you copied somebody's work. Right now, today, we infer copying from similarity. Right? If your painting looks virtually identical to mine, we assume you copied it from me. We can't do that anymore. Right? We don't know right, whether two identical works or similar works came out of the same prompt or not. Right? They might have been independently generated by the AI. It's much easier to stumble on the same prompt than it is the same sequence of brush strokes. Conversely, even if I do copy your prompt, I actually set out to generate an identical version of your work, right? Random seeds mean that even a complete effort to copy the thing might generate different AI output. And it's going to be really hard to know where there are similar but not identical works, whether those similarities are because of the sort of human-contributed modification elements or the AI-contributed and therefore uncopyrightable pieces of the work. All right, so what do we learn from this overall? Training suits, I think, are an existential threat to AI, but they're probably going to lose. They've lost so far. I think they will continue to lose. Depending on the market, there's probably going to be some licensing. That's going to be especially true in markets like music, right, where there's more concentration and more value. There's going to be some in cases involving infringement of output, fewer than you think. You can manage some of that with safeguards and other technical design to try to reduce the risk. We're also going to fight over the question of who's responsible for that output, right? Is it the individual who tried really, really hard to get the prompt to generate the New York Times story, or is it the model? The courts have not yet confronted that issue, but I think they're going to have to. And then if we really are moving to a world in which kind of 90% of code and an increasing amount of our text and image content is generated by AI, we may be moving to a world in which copyright law, copyright protection shrinks dramatically if it doesn't disappear altogether. You might look at that and say, awesome. Right? We've been trying to get rid of copyright law for years, and now we can finally do it. If you are in the industry, you probably look at that and say, oh, crap. You're telling me that if I use AI to generate all the backgrounds for my video game, anybody is free to make an exact copy of those backgrounds of the video game, and I can't stop them. And I think as these things get more and more valuable, there's going to be a political push to say, change the rule. We want to own this stuff, even though we didn't, as humans, create it. And it might be that we should just need to give up on the idea that only humans can create, right? We had a similar issue come up in photography 150 years ago. It's the machine that's making a copy. All the human does is press a button. Went to the US Supreme Court. The US Supreme Court ultimately kind of said, yeah, you know, there's a bunch of human effort in 19th century photography, right, designed in making that picture, right? You gotta do the lighting and you gotta set it up perfectly and figure everything out and place the person, and then you gotta decide how long you're gonna do the exposure. And so it said photography is copyrightable, not theoretically the machine parts, but all those human choices about what went into photography. We then forgot that distinction over the next 150 years, and now we just say photography is copyrightable, even as we have made it so that you really are just pushing a button, or in some cases not even that, right? The phone will take a bunch of pictures and decide which one is best for you. We may be in the same situation with AI, where we're ultimately going to have to decide, you know what, this seems like something we've protected under copyright law. Humans aren't really creating it, but we're going to give them rights to it anyway, because giving rights is what we know how to do in the IP regime. And with that, I'll stop.
Let me start sort of where I thought I was going to end, which is what answers do we need? I mean, suppose that you were king of copyright.
God help us all.
Beyond the walls of Stanford, right? If we had legislative fixes to this, the Lemley law related to copyright, both I guess on the normative side as to what you think is desirable, but also just in terms of removing ambiguity that currently exists in the law, what should we be doing?
Oh, yeah, okay. Well, so I'm like, first of all, I think there are technical answers we need, right? We are very early at figuring out exactly how much kind of memorization goes on, right? And as we've been doing more research, we find different models. One of the interesting things to me about working with computer scientists in this field is learning just how little the experts and the designers themselves know about what these things do and why they do it, right? So learning actually when we're actually likely to get a copy is going to be really important stuff. I think one of the things we're going to have to resolve is the sort of question of like, is the model a copy? gonna have to resolve that legal question. I think the answer probably ought to be no, at least unless you can really deterministically generate an output repeatedly in a case like Harry Potter. But it's going to be interesting to see how the courts or the Congress deals with that. We're going to have to resolve this idea of market dilution, right? This idea that the judge I mentioned earlier said, hey, sure, your output isn't anything like the plaintiffs, but it's competing with them, and you used the model to get you there, so it's infringing. That strikes me as something that's really pernicious, and if we declare it to be the case, is basically going to give a whole bunch of people legal rights over AI. And then I think the sort of bigger challenge from a copyright perspective is, does copyright sort of parachute in and say, this is all illegal, anybody can stop it? In which case I think it's really hard to build models, at least in the way we've already traditionally built models. Does it say this is all fair use and it's fine and we get out of the way, and none of it's owned and we get out of the way, in which case copyright sort of withers into irrelevance? The way we've responded to a lot of technologies in the past has been this, to find a middle ground and to say, oh, let's create a compulsory licensing regime. We don't want to shut down the model, but we want to make sure copyright owners get paid. So I think there's going to be a lot of push either on a private or a kind of public ground towards creating some sort of compulsory licensing. I don't think that works well for many industries. I think you could probably do it in music, right? The ownership is concentrated enough, the needs and the use are concentrated enough. You could probably build a licensing regime. I don't think you can build a licensing regime for everybody's website, right? Every image that's on the internet. At least not one people are thinking about, right? So I think about Stability AI, right? Trains on a couple billion images. The company's worth about $1 billion. Even if we say, let's take half the value of the company and give it to the copyright owners who we trained on, everybody gets 25 cents. And when people talk about a compulsory licensing model, I don't think they have in mind, okay, I'm going to get paid for training, I'll take my 25-cent check, and now I'm happy.
So let me ask you about memorization and some of the points you're making. It seems to me that at least the way you have portrayed the question is that whether there's memorization, whether there is a copy of the model is actually a function of the output, right? Which you wouldn't think that would be the way that you would analyze whether there is a copy or not. And so therefore it sounds like you're making kind of an economic argument or about the implications of it being memorized as opposed to whether there's actually a copy of the model.
Yeah, so it's a good question. Let me distinguish two things, both of which I think are kind of interesting. One is because we don't know what models actually encode or how they function very well, right? One of the ways we prove that memorization happens is by extraction, right? And so a lot of so on the technical side, the question of is there memorization at all? The only way for us to know the answer to that question is to try various attacks and approaches to try to extract things from the model, right? We can't just look at the model and the weights and say, oh, I can see that Harry Potter's in there. Then on the legal side, right, then the question is, what do we learn when we do that, right? One thing we learn for some books like Harry Potter is, boy, yeah, it's in there. It's easy to get out. If you just say, give me the greedy decoding approach, give me the highest percentage each time, you'll get Harry Potter, and you'll get it again and again and again if you use certain search tools. And I think at that point you have to say, yeah, there's a copy of Harry Potter in the model. But I think there are going to be a bunch of books.
Let me just cut you off there because the probability that it's going to spit out the book.
Why does that matter? Right.
Like, So we know why it fails or succeeds, if you want, on the Harry Potter thing that it doesn't on the other books, which is that there's a lot more Harry Potter in the training data, right?
Probably, maybe they oversampled on it. That's probably right. Yeah.
Well, I don't know why they
we don't
particularly train on Harry Potter, for a general purpose model.
Yeah.
But so all right, so that's just a feature of the internet, right? Is that you have a lot of, or the training data is that you have a lot of copies of these things. I don't know why that would be. It would affect the answer to the question as to whether there's a copy in the training data.
Yeah. So here's.
By the way, let's be clear. There is just as much of the ingestion of any book, right, is done in the same way. The question that we here, it's just that it's ingesting more of them that then makes it more likely that it's going to end up in the output.
So here's the problem, and it's something frankly that we're struggling with. Cooper and I have a new paper on this probabilistic copies issue, right? The challenge is, right, if you think back to the tree that I showed you, right, for each token, I've got a tree with a probability that I'll go in a particular direction. And so even for a relatively short work, you might have 1,000, 10,000, 100,000 branches on that tree, right? And one of those branches on each one turns out to be the work. So if the question is, oh, well, wait a minute, right? If I follow a particular set of 100,000 branches, I will get the work. Therefore, there's a copy of the work. I think you also have to say there's also a copy of all the paths not taken. Right? That exists in the model too. Well, exactly. Yeah. And that's the question from a legal perspective, right? Well, what does it mean to be a copy, right? And so I think my best assessment, and we're working blind on this, right? The courts have never had to deal with this because we've never had this technology. My best assessment is at some point you can't say everything that might possibly be generated from that tree exists in the model now as a copy. We're already well past the number of atoms in the universe, right? At that point, they can't all be copies in the model. So what I would say is, when is a copy made of a work that is randomly generated for the first time by a model, right? Or generated that happens to sort of match Harry Potter? It's made at the time that the output happens, at the time that you request, and the model generates an output that follows down those trees. That doesn't mean there isn't a copy in the output, but I think it does mean we don't necessarily assume that the copy is resident in the model before you ever generate it. The closest analogies we can find to in copyright law cases come out of video games. And so here you might think about if I build a map, right, that will call on particular assets to generate video games, and it does so deterministically, right? You'll plop the monster here, you'll plop the treasure chest here, even though the map doesn't itself contain any of that. It's a sufficiently clear, replicable map that we would say that's a copy. But if you took a game like No Man's Sky, which generates a world procedurally for the first time whenever somebody shows up to it, I don't think you could say all possible planets they would generate are in the model in a saved or fixed form, right? We will generate them, and once we generate them, there's a copy, and we've made them. I will say I don't love this answer. It seems to me inelegant, right? But we're trying to kind of work through what the law would currently do.
Part of it is I sort of want to liberate you from thinking about it in these terms, in these kind of traditional terms, which is that, because the output question and the training data question are now collapsing onto themselves, right? But if you look at it this way, and so I might ask, well, suppose I have a photographic memory, right, and I read a book, Harry Potter, and there's a copy in my brain. There's no copyright problem.
Well, right. Although this turns out to be because we've basically just decided never to ask the question where humans are concerned, right? The case for there being a copy in the model, I think, is in some sense not as strong as the case for there being a copy in your brain. But we just don't want to go there, right? And so the law just won't actually look at that, right? But it is probably there are parts of movies that are indelibly fixed in my brain, right?
Songs, that's one, right? Clearly, we all have sort of copyrighted materials memorized in our brain. We don't think that.
We don't want to make.
And so this is why the output question ends up driving the whole car here, right? Because ultimately, we don't really care so much about the actual copying in the model if there is no risk that it's going to produce it.
Yeah. And so if the question is how would I design the system, I think that's the way I would design the system, right? That is, we shouldn't care what's in the model. We should care what does the model generate as output, and if it generates infringing output, then you should be liable for that, but not otherwise.
I'm sure there are a lot of questions in the room and online. Let me start with Daphne Keller to start.
Mike is picking you up. You're good.
Yeah,
awesome.
You'll be picked
Okay,
up.
so I have kind of a hand-wavy information policy question. Copyright nominally exists to promote the progress of science and useful arts, which is an awesome goal, and it has some cool doctrines to do that. But what's happening right now is that online, at least, the rights holders who think they might make some money off of licensing are locking everything down so that it's behind a paywall, it can't be crawled, it can't be indexed, etc. And the content creators who are not as economically motivated because they are propagandists or academics, or whoever publishes for free.
Sometimes the same.
Our stuff gets into the models, right? So we're creating this situation where the best and most reliable information that we should want to encourage is not getting into the answers we get from AI, kind of because of copyright. How do we get out of that?
Yeah, no, it's a great point, and I'll actually take it a step further, right? It's not just that, right? It means we're getting our news from Chinese and Russian state media because they're perfectly happy to sort of send this stuff around, or the Daily Caller or whatever, right? But that we are in the process of locking down the open internet, right? And so we're losing, right, this sort of thing that actually is incredibly valuable because people want to lock it down. What do you do about it? Here are a set of possibilities, right? You might imagine, let's rebuild the robots.txt header so it actually then distinguishes among different uses, right? That doesn't solve the information problem you're concerned with, but it might solve the locking down the internet problem. If I can say, please, web crawlers, search and index me for purposes of internet search, but not for purposes of AI, my guess is a huge number of websites do that, and then at least they're not locked down. Maybe we solve the problem with licensing, right? And so if news like music becomes one of the things where there's a sort of plausible licensing story, and the AI companies care enough about getting accurate news responses that they're willing to go grab things from the sort of few remaining viable true news sources in the world that haven't been sort of bought up or owned by one side or another, then maybe we get better news that way. A third possibility is what Cory Doctorow calls adversarial interoperability. And so one of the things that I'm kind of playing with right now is as we see that lockdown, we might affirmatively want to intervene to make sure that copyright law and other laws like the Computer Fraud and Abuse Act or the sort of contract laws can't be used to prevent people from engaging in sort of scraping or access to things that are otherwise open to the world.
Yes.
Yes, I'm Gus, visiting from London as a researcher. I would have to, as a former software person and a person that is studying cognition, I would have to maybe just put a note there that when we are remembering something and making memories, we are actually compressing a memory in our mind. So humans do it through chemical reactions. Roger Penrose maybe thinks that there are quantum effects in play, and computers do that with electrons. And then the question is, so the precision of the recall or the recompressing into the output very much depends on many things, but one of those things is what is called the quantization of a model. Basically, very simplified, is how many commas or the number has, or the weight of a model has when we actually serve it. So the thinking Google model has lots of numbers after the comma in a floating point, and the quick fast models have not that many numbers. So my question is, from the legal doctrine perspective, was there an inquiry in kind of mapping those kind of engineering kind of concepts into like quantization and how smart or not smart the model is into the legal doctrine?
Yeah, no, I think it's actually a good analogy, right? And it is kind of, I think it's one of the challenges that I've seen in the sort of law and computer science world is, right, when computer scientists use terms like compression or memorization, they have a very kind of specific meaning in mind, and lawyers take those terms and run with them, often with somewhat different meanings in mind, right? But I think it's right to say that there's a kind of interesting analogy to sort of how, and also how well we encode data, right? Is that compression lossy or lossless? Does it sort of generate its own kind of new state? And I think we probably should see that play out on the output side, right? So that is, if I can generate word for word all of Harry Potter, there's obviously a kind of level of memorization that is either the equivalent of lossless compression, right, or something very close to it. Or we've reinforced the equivalent of the neurons, right? We've reinforced sufficiently strongly that we've built those pathways. For lots of other things, I think those pathways are not as strongly encoded, and so you're unlikely to see the kind of same level of output similarity.
We're getting lots of questions over Zoom. Let me just ask one of them, and then we'll return to the room. And this has to do with the copyrightability of prompts. And the question is it clear that the prompt is a user's IP? Companies are building prompt repositories that once popular let agents do the work the prompts are used to do. Should prompts be protectable, and who owns them?
Yeah, right. Okay. A lot of that there, right? Should prompts be protectable? Yes, if they are creative expression. Often they're going to be ideas, right? Penguins having a cocktail party at the beach is an idea. I can't own that, even though I came up with it. Right, a more detailed prompt with a kind of lot of, but I want there to be a kind of ocean with 3 mountains in the distance, and it's near sunset, and the sun is setting from the left. At some point, there is kind of creativity in the design I add in, but that creativity is going to be very limited. Let me insert the question of does it matter, right? I think like 2 years ago, I would have said, this is if there's going to be any copyright protection, this is where it's going to exist. The Copyright Office says, yeah, we don't care. Prompts, I don't care how you prompted it, right? The output came from the AI, and that's all I care about. Nothing's protectable. I'm not sure that, strictly speaking, should be right either. Then the question, who owns it, right? Which I think is a really interesting one. The AI companies have so far been of the view that, you know what you do with our model is your business, and therefore please don't hold us liable for it, but also, and therefore you can have or do whatever you want with the output that is generated. And so what you might have expected to happen with kind of standard form contracts, which is we own everything, you own nothing, right? They have not done. The AI models have mostly gone in the opposite direction. The challenge there, and I think the question adverts to it, is I write a prompt and I get an output, and I probably I get to do whatever I want with the result. I own that prompt. Increasingly, though, the way AI is giving us the answers we want is by rewriting our prompts without our knowledge to make better prompts. My favorite example of this is one that Casey Newton gives, right? So when he prompts Midjourney, he wanted a picture of a kind of film noir badger detective. And so he asked for it. It gives you 4 different copy possibilities. For each one of those, it rewrote a very different and detailed prompt that said, it's night, there's raining outside, there's a slatted window, there's a gun on the desk, and various other things. The AI generated all that because it thought, oh, that seems like things that would go with film noir. And then the AI refused to give him one of the images because it said it violated its own safeguards. So it generated its own prompt and then said, oh, but I can't give a response to that prompt. That violates our safeguards. We don't know why. The more the prompt is actually generated by the company itself and not the individual, I think the more challenging it's going to be to say, I've got any ownership rights and therefore any copyright rights in it.
Great. Going back into the room. Yeah, we can.
I have a question about I'm really interested in these licensing deals and the idea that licensing was a reason why, or no market for licensing was a reason why some of the courts found fair use. But the deal I was wondering about was the Sora Disney deal, which this might be a moot point because Sora's gone now, but it seemed to me that Disney was giving OpenAI, investing in OpenAI $1 billion, and then in exchange, Sora would be able to generate 200 of Disney's characters. So it kind of flips the assumption with the licensing and almost it's like advertising for Disney or something. So I'm just wondering about kind of this common idea we have that licensing is going to compensate the creators, why that deal kind of happened, or if that might happen in the future.
Yeah, and as to why that deal happened, I have no idea, but I had exactly the same reaction to it you did, right? Which is, if the licensing price is negative $1 billion, right, you may pay us for the privilege of allowing us to use your data in training and in outputs. That does not bode well for a licensing market that's going to compensate all of the creators for the use that's being made of their works. Yeah, I agree with that. I mean, I do think almost without regard to sort of like which way the money flows, right, or how the money flows, I do think under current copyright doctrine, if we look and we say, boy, there is an established licensing market, people are signing all these deals, it is much harder to say, and therefore the use without signing a deal is fair use. Jacob Nodi Victor and I have a paper called Anti-Competitive Acquiescence, where we look at a dozen different circumstances, including AI licensing, where where companies that are winning their lawsuits or their disputes nonetheless end up sort of signing deals to agree. One reason they might do that is that we got in on the ground floor. We trained on the open internet. Now there is no open internet anymore, thanks to, as Daphne points out, right? And now there's a licensing market. Anybody who wants to come after us faces a cost structure that is prohibitive, right? And so the companies that are in on the ground floor may be the only ones that stay in.
Just a follow-up. Isn't this Disney is doing this because now AI models, if they're really good, Disney doesn't need creators and artists to generate those characters? I think Netflix is going to move towards the same goal. In
terms of using AI, absolutely right. I think the Hollywood companies are really excited about the possibility of kind of cost reduction, easier generation of stuff. Video game companies especially, because you got to render all that stuff anyway. But whether it explains the Disney deal, right? And we don't know the details of the Disney deal, right? So
There has to be.
Yeah, there probably was some kind of like, and yes, so maybe the answer is Disney was going to get sort of unlimited free tokens to design its next movies, and that was worth it to them. Who knows?
So do we know actually did the whole deal collapse because of the source? So
Yep.
Yeah, that's what I figured. All right, let me just go back to Zoom, which is, and Adrian, also feel free to jump in if you have a particular question from Zoom. This is about Europe, and what the questioner asks is the EU's two-track regime enables public interest AI like university-trained open source LLMs on national library collections. Can you comment on that, Mel? Is the research exception effectively a constitutional move about who controls knowledge infrastructure, not just a copyright rule? Does that make sense to you?
I think so. So I confess that your knowledge of European law is definitely not my strong suit here. I think part of it might frankly just be a function of when we wrote the law and what we had in mind with it, right? So there's a text and data mining exemption in European law that sort of has kind of nonprofit uses, academic uses, university uses in mind. It doesn't necessarily extend to sort of these commercial uses.
Can I just ask, expand this just to the international dimensions of copyright here, what the future holds in terms of potential licensing regimes?
Yeah.
And drawing on the music industry or what else, other models for compulsory licenses. I do a lot of work and talking to government officials around the world on this, and take a place like Brazil, the Brazilian music industry, like this is the issue there, right? This is like a really big deal, and it's like, well, you might think that there are going to be these bespoke deals.
Yeah, so right. So first thing to know is like almost no countries in the world other than the United States have a fair use doctrine, right? So the thing that has made training legal in the United States does not translate abroad. A bunch of countries, but certainly still a minority, have a text and data mining exemption that allows sort of access to information. And again, I think those are mostly written, so Israel, Singapore, Japan, Europe have TDM exemptions. They are mostly written in a pre-generative AI world, and so they're mostly written with the idea that we'll use kind of machine learning, but we'll use it in terms of collecting kind of data and aggregating and use of data, and I don't think they had the same sense of use of the content. It's not clear that they would extend it to those. So then there are a bunch of countries, right, for which the answer is, well, you'll either need a license, right, or Europe with the AI Act is talking about, well, you can do it, but you need to have an effective opt-out regime in place, right, so that anybody who doesn't want to be trained on cannot be trained on. And so one big sort of meta question in the international environment is whose laws apply. We had a similar issue come up at the dawn of the internet 30 years ago, right? I can build a website in one country and it's available anywhere. And there we kind of mostly ended up with all right, everybody's laws apply to you because you're accessible anywhere. Maybe you can geolocate and kind of not be in Pakistan where they say your content is illegal. But if not, you're going to be in trouble. I'm not sure that same thing's going to apply for AI. Right? If I build my model, I've trained my model in the United States and it's protected under the fair use doctrine in the United States. I think Europe has some ability to say, don't generate certain kinds of outputs that violate our rules. But I don't think Europe has the ability to say that act of training in the United States of a model that resides in the United States is illegal in Europe. And therefore you have to kind of undo it. But they probably will try.
Let me ask you something I wanted to ask you for a while, which has to do with the settlement in the Barch versus Anthropic case. And this has to on the
which I probably can't talk about.
Oh, okay.
I mean, I'll talk about it if I can, but I have represented Anthropic in that case.
Well, this is just on the question of the illegally obtained book, just as a theory of copyright law, right? So there's the distinction in the case between the Books3 database, right, and that's seen as thefted in a sense, right? That they were training on illegally obtained by someone data or covered material. Had this gone to, I mean, what do we think about that as a legal ruling, where it not a?
Yeah, all right, I will tell you what I think of it as a legal ruling and make it very, very clear that I am not speaking for Anthropic in any way, shape, or form. So I think it misunderstood copyright law, right? That we have various other fair use cases in which I got the thing unlawfully, but the use I made of it was a fair use, and we did not say, ooh, you got the thing unlawfully, therefore we short circuit this, right? And that's illegal, right? So in Harper and Row, the court ultimately concludes it's not a fair use to copy the text from Gerald Ford's memoirs, but they do not say, oh, because you stole the memoirs in order to write the story, we short circuit fair use, you're separately liable for that. They treat it as an integrated question. You took this book and then you made a use. Is that use copyright infringement? In the Time versus Bernard Goetz case, where Geis breaks into the Time Life building to get access to the only copy of the Zapruder film stills to prove his conspiracy theory about the Kennedy assassination, right? The court says that is a fair use, right? You can use those things, and we don't care that you broke into the building to get them because the use you made of it was ultimately a lawful use. So I think the court should have said, yeah, Books3 may well be liable for posting books illegally on the, but if the only thing I did by accessing that Books3 database was make a use which I have determined to be fair, that should not be illegal. The fact that the judge clearly did not think that, I think, opened the door to a potential flood of statutory damages, right? So if there's 5 million books in the Books3 database, right, and the judge clearly thinks you're a bad actor, the possible multiple damages at $150,000 a work, right, is worth even more than Anthropic, right? And so I think the thing that one of the reasons we have a settlement with a $1.5 billion payment is it's not because of the training, right, which the court says it's fair use. It's because of that sort of novel theory of copyright coupled with high damages.
But this would, if that's the rule, then were a model to, jump over a paywall without paying, right? But
then they would be in trouble, right? But so here's the problem.
Which is a separate. That's not this case. Right?
It's not this case, but here's the problem I have with it, right? So the argument here is you deliberately went to Books3 and you knew that it was unlawful, right? But every model trains on Common Crawl. Right? Common Crawl is everything out there on the internet that people have said, yes, please, spiders, please come index me. It turns out that some substantial fraction of the websites on the internet, people are perfectly happy to share with the world, themselves copied things illegally from other people. There is no way to know which websites on the world, right, turn out to have unlicensed content, and copyright infringement is a strict liability offense. So if we say, ooh, you got it from a source that turns out to be unlawful, unlawful, so you are liable no matter what you did with it and whether or not that is a fair use. We basically say nobody can use Common Crawl without risk of potentially devastating liability, and that strikes me as a bad idea.
All right, let's go to one last question from Zoom.
Question from a former student. If I hold a broad pre-AI license, so worldwide irrevocable derivative works, technologies now existing or ERA upgraded, does that cover feeding the work to a model, modifying with AI, or training a private model on it? Or is explicit AI use language now?
Yeah, so I think the answer is it's going to depend on your license, but probably yes. The reason I think probably yes is that we ran into this problem with the internet. People had written a bunch of licenses, and then the companies they had licensed their content to wanted to put their books or their newspaper archive on the internet, and the courts said, oh no, the license didn't specifically mention internet because it didn't exist at the time, so no license extends to the internet. And as a result, everybody went back and rewrote their license in ways you just described, right? Any mechanism now known or later conceived anywhere in the known universe, let's make this as sort of incredibly broad as possible. So my guess is that we're going to read those licenses as covering technologies that did not exist, were not contemplated at the time the license was written. But again, it's going to depend on what the license specifically says.
Well, I think this was a great conclusion to our seminar series. Thank you, everybody in the room and online, for joining us for this. And stay tuned for what we have in store for the fall. But for now, please join me in thanking Mark Lemley.
Thanks.